Department 9 is now in session.
Yeah, sounds makes sense. If I'm gonna go back and sell jury instructions, but yeah, if I'm running late, it's a 3:30 status check over federal court.
I think, but
Practicing law is easy, running a business is what will drive you to distraction.
All right, we're back on the record in case C-18-333-684. Did the parties get a chance to review each other's jury instructions?
Yes, Your Honor.
Yes, Your Honor.
All right. I'm going to start with the state's. Mr. Mueller, do you have any objection to any of the state's instructions?
No, state, looks like these are all stock instructions, as I'm sure you know by now, we usually, custom and practice is to use the state's instructions unless there's something not covered.
These all seem standard to me as well. So I'm inclined to accept all of the state's instructions. I did think, though, that perhaps we should add a part or add another instruction. And so you go 7 pages into the state's proposed instructions. It's the one that says, you are here to determine the guilt or innocence of the defendant from the evidence in this case. Oh. I'm sorry, Mr. Mueller. No, I didn't realize you hadn't walked out, or you were standing there putting your tie on. I apologize. Welcome back. I feel like we should either add a part to that or add an instruction that directs the jury to not speculate what occurred or did not occur during the divorce proceedings that were discussed during the course of the trial, except to only consider them for what bearing they have on the evidence in this case. Does that make sense?
Sure.
Yes.
Mr. Mueller, I know
Yes,
that
yes,
distracted. Did you hear me?
Yes, I did. Conceptually, I don't have any problem with that, Judge.
Okay. So we'll draft an instruction that says that. And I think we'll make it a separate instruction. So I'll have it follow this instruction, if that's okay with everyone.
That's fine with the state.
Okay, all right, so we'll do that shortly. And then the next instruction is the stock evidence instruction regarding the evidence they're allowed to consider, which is the testimony, witnesses, exhibits, etc. I think we need to add a couple of words to the second to last paragraph, which reads, you must disregard any evidence to which an objection was sustained by the court and any evidence that was ordered stricken by the court. I think we need to add ordered stricken or to be disregarded by the court.
Yeah, I like that. I think that this should be a part of the stock one. It's a good advisement regardless of the case.
Okay, all right. Any objection to adding those 3 words in, Mr. Mueller?
No.
Okay. Just want to make sure, I've just gone through to make sure I didn't miss anything else that we needed to add or take out. Does either party, other than my instruction regarding divorce proceedings, request a bad act of, I guess we'll call it bad act or a bad act-like instructions?
So instruction,
As an example, there was the phone call relating to Mr. McDonald's lack of child support payment. I mean, that is kind of related to the divorce proceedings that we're going to add that instruction, but I'm wondering if either party wants an instruction regarding that.
No.
I think that's covered by the instruction we just discussed about
Okay.
the purpose of the divorce proceedings.
Okay, all right, just wanted to make sure. All right, so let's turn over to the defense proposed instructions. So the first instruction proposed is not unlawful to possess audio files. The state must prove that the audio files were recordings of phone calls and the recordings were made without consent in the state of Nevada. So I believe that this instruction is covered by the state's proposed instructions regarding what constitutes a wire interception. It specifically tells them, this is page 16, I know they're not numbered, but it says a person is not guilty of an unlawful interception if it didn't happen outside of Nevada. So I'm not inclined to give this instruction. I believe it's covered by the state's instructions.
That's the state's position.
I object, Judge. Specifically, my colleague, until I kept making the issue, it continually called the audio files phone calls. And it wasn't in evidence, and encourage the jury to confuse the audio files with phone calls.
Well, Ruiz did testify during her testimony that they were phone calls. So ultimately, that will, the jury will have to rely, or will have to consider and weigh her testimony, whether they believe her testimony, whether or not it is an actual phone call. So I'm not going to give this instruction. The next instruction is testimony in this case was produced that of one version of an audio file contained a warning that the call is being recorded. The state has not produced that version. You may infer that it would not be helpful to the state's case. This is a request for the code of an exfoliation instruction. Mr. Mueller, what evidence do you have that would entitle you to an exfoliation instruction?
We have not one, but two witnesses in a 4-witness case have said that they've heard an audio tape that says that this court, these conversations are being recorded. We have not had such an audio tape produced, including apparently through the evidence of a search or efforts of a search warrant. We only have the self-serving testimony of 2 witnesses, Bill disclosed to Mr. McDonald, that those witnesses did not deem it credible. The state hasn't produced this document, or produced this, and that's exactly what, I mean, strictly speaking, it's Brady and it's exculpatory, and respectfully, I've complained bitterly about this since the beginning of this case. But now I've got 2 people who testified that it says it's not, or this phone call being recorded, and the state hasn't produced it. So if they haven't produced it, it's because they don't have it, or they haven't, there's potentially exculpatory evidence out there that the state has not obtained.
Well, how do you address the fact that there was testimony from, at least from Mr. DeCiro, that the recording was taken down off of YouTube?
It would be wonderful if, Mr. DeCiro certainly seemed to have lacked no ability to get these recordings off of the Google Drive when he wanted them. But now since Mr. McDonald's now been in custody going on, what, 9 months? 7 months, now we can't, suddenly he's lost his ability to get a hold of these recordings.
Well, if you look at the exhibits that were introduced, the Google Drive showed a hyperlink to the YouTube channel. So if an individual were to click on that hyperlink, which you could do even if you cut and pasted or type the hyperlink in, how is it the state's issue if that hyperlink is no longer active?
The answer is, Judge, the state has the burden of proving the case beyond a reasonable doubt. It is not a crime to say, hey, I'm going to record you because I don't like you and I don't trust you. And then later, a audio tape shows up that's been edited that has that word redacted. Now, if the state believes that this recording is illegal, then why don't we have the audio tape that both 2 of the 3 witnesses have said they've heard? Now,
No, that wasn't what they heard. They watched a YouTube video that had an audio part of it.
yes, the audio tapes that you've heard are lifted directly out of this YouTube video. This was the soundtrack that went with the video. At least that's my understanding of the state of the evidence. Now, the state has not produced the potential exculpatory audio. And I've complained and asked for relief on the fact that this audio tape has in fact been edited and reformatted and does not contain hello or goodbye with one of the conversations that
Well, the last one will actually did say goodbye,
Again,
yes.
I'll retract that. But having said 4 of the 5, of the 10 potential greetings or goodbyes, we've got 9 of them are missing. So, Your Honor, I believe that's a proper instruction of law. They haven't produced the evidence that they say they've seen. Well, where is it? And if they can't produce it, then I think he's entitled to a spoliation instruction.
So tell me how something that would be, I'm guessing I'm again demonstrating my lack of techiness, but hosted by YouTube would be in the care, custody, and control of the state of Nevada.
These documents were hosted by Google. I remember that was Mr. DeCiro's.
So that's the Google Drive, that would be
Google
hosted by
Drive.
Google, but we're talking about the YouTube videos that both testified to that had the quote-unquote dubbing of this call has been recorded.
Mr. DeCiro testified he heard it, okay, that he's, and Mr. McDonald's ex-wife both have listened to it. But when it comes time to prosecute the case, neither one of them can find it. Now, perhaps I've gotten a little cynical over the years doing a lot of criminal law, but it would appear to be a remarkably self-serving state of affairs.
Now, the fact that they cannot produce this, and so that the jury themselves can determine if it's dubbed or edited, is an inference that Mr. McDonald's entitled to. He's entitled to an inference that the state hasn't produced the case and it's not helpful to their case.
Okay. All right, well, I'm looking at Bass hyphen Davis v. Davis. It's and actually a case that you provided in relation to your proposed instructions, Mr. Mueller. It's a 2006 case from the State Supreme Court of Nevada. The citation is 122 Nevada 442. In that case, the Supreme Court discussed the district court's broad discretion to settle jury instructions to include the decision whether to give or decline or oppose instruction. In that case, they were actually talking about a spoliation instruction. The court is to examine the relevant facts, apply the proper standard of law, and utilize a demonstratively rational process to reach a conclusion as to whether or not an instruction should be given. In listening to the evidence in this case, I am declining to give this instruction. I do believe that there hasn't been any evidence elicited that the state destroyed or refused to produce any evidence that was in their care, custody, or control. The testimony that was introduced through Mr. DeCiro was that he could no longer access the YouTube videos after a certain period of time, and that goes to the weight, not the admissibility, and nor is there any inference that the state did anything to prohibit you from having access to that. It was a publicly hosted video on a publicly hosted website, and if that video did still exist, you yourself as the counsel for the defendant or the defendant himself could go retrieve it off of the internet. And I don't have any evidence that that was attempted or that it no longer exists. So I'm going to decline to give this instruction.
I think Your Honor, respectfully decline or disagree with the court's ruling. I believe it's an error, and respectfully, your reasoning apparently produced or put on my shoulders a burden to obtain evidence.
No, it's no burden. I acknowledge you actually have no obligation to retrieve it. I'm really making that statement to make it clear that this was information that wasn't in the care, custody, or control of the state, but rather information that was publicly available. And per the testimony of Mr. DeCiro, no longer publicly available to, at a certain point, for review. All right, let's move on to your next proposed instruction, which is the audio files are not in evidence. If you believe audio files were edited, the audio files may not be considered in your deliberations. You cite to the same case I talk about with the spoliation instructions. I respectfully disagree that that case stands for that.
Respectfully, Judge, here's the state of the evidence as I...
Hold on, let me go ahead and let me talk about this. The Bass-Davis v. Davis case held that considering the potential consequences to the non-spoiling party, so first off, there's a distinction there. The court had made a determination that the party was entitled to the spoliation instruction. We conclude that NRS 47.250 subsection 3, the rebuttal presumption that only applies in cases involving the willfully destroyed evidence. However, the jury, when properly instructed, is permitted to draw an adverse inference when the evidence is lost or destroyed through negligence. In this case, we have no evidence of a willful destruction, nor do we have evidence or an inference that the evidence was lost or destroyed through negligence. And so I'm declining to give this instruction, but Mr. Mueller, please lay your record.
Respectfully, Judge, we have a troubling state of evidence. We have two state's witnesses of the three and a four-witness case said that there's two versions.
It's a three-witness case, so two out of three.
Three-witness case have said that there's two versions of this audio tape, one of which would completely exonerate Mr. McDonald, specifically a statement saying that this case, these phone calls are being reported. Yet neither his ex-wife, who clearly, I don't think can reasonably be described as anything other as harboring ill will towards him, or Mr. DeCiro, who very clearly has some animus towards him, have been able to come up with the actual audio tape. They opined that the dubbing that was dubbed and poorly dubbed, but once again, these tapes have been reformatted and they have been clearly edited.
Now, perhaps I've gotten a bit cynical over the years, but edited and adulterated evidence is not admissible or probative.
Okay, so I think the operative point of your argument is that there were a YouTube, or there was a YouTube video with the, as it's been testified to, and I'm putting it in air quotes, dubbed version of the statement, this call is being recorded. But there's been no evidence presented that those recordings still existed at the time that Ms. Ruiz made the report to the police, or that the police began to investigate this case. So, I'm just not sure how you would be entitled to this instruction.
Well, respectfully, Ms. Ruiz became incensed 2 years after the fact, after she heard the first version, which apparently said that this call is being recorded. That version is not forwarded to the police. Somehow it's Mr. DeCiro's edited version that somehow makes it the police records. Police officer very clearly did a minimus amount of
What evidence is
investigation.
there that he edited the recordings?
We have his, the format has been changed.
Number one. Number two, the audit trail. I hired an expert look at this stuff.
But the expert didn't testify.
No, he didn't testify because there's nothing there to testify to. And I called my colleague up and said, look, where's the rest of the file? It starts and stops. The rest of the file's been gone. Somebody's cut this very tightly.
Okay, but what is the evidence that Mr. DeCiro or Ms. Ruiz or anyone else, if it was in fact at all edited?
It actually has been edited. That's not me, Lee.
No, but there's no evidence of that.
No, there's no
I'm
evidence.
not introducing evidence where I haven't gotten to your case in chief, and that's not lost on me. So what evidence is there to support, and what evidence will there be to support that it was edited? Edited.
Well, actually, the emails, they've already introduced the emails. It said the format, the detective actually, she went out of her way to introduce the email that says, I can't read this format, he reformatted it.
Well, reformatting it is different than editing it. That makes it a playable format.
I think to a near certainty that the court could be comfortable if they've been edited. None of the conversations begin with the word hello, and there's 5 of them. Now,
Well, how could that mean edited? What if someone just turned on the recording midway through the conversation and then turned it off?
that's speculation, that's the prerogative of the jury judge.
Right. Okay, so I think to that end, we're agreeing that ultimately the credibility as to whether or not these were edited or not goes to the weight of the evidence and the weight of the audio files, not the admissibility. They have already been admitted. And so again, I go back to if there were original audio files that were located, that were unedited, and they would be located on Mr. McDonald's Google Drive.
You may recall when we began this trial that we objecting to the best evidence rule and that
Right.
the original document or edits. My colleague didn't disagree, these aren't the original recordings, so they're not even disagreeing with that. This is what has been presented and provided are edited audio files. The originals have never been produced, and to the extent that the state has them, I don't believe they have them either, but the original files are not to be found anywhere. Now, that's the problem, one of the fundamental problems with the case. The files get produced by someone who clearly has animus towards Mr. McDonald's and admitted has the expertise to edit files. He's a radio disc jockey. Now, this case is in a broader context down in family court. We've gone through this before, but respectfully, Mr. McDonald's, these are not the original files. Nobody can produce original files. The jury needs to know that, and they're entitled to use that fact.
Okay, well, the proposed instruction is actually a misstatement of fact. The first sentence says, I guess you're saying the original audio files, but audio files are in evidence, and there is no proof one way or the other that those are or not actual copies of the instruction, or of the audio files itself. And so giving instruction would be confusing to the jury, and telling them if you believe the audios were edited, you may not consider them as actually improper. They can certainly consider the evidence that has been introduced, and they consider whether or not they were edited to weigh that evidence against all the other evidence or
Right.
the other evidence in the case. So this is a misstatement, and I'm not going to provide this instruction.
All right, Your Honor, and respectfully, if you would, so we can amend this, if you believe the audio files were edited, you may consider that in your deliberations.
state, I'll hear from you regarding that.
And Your Honor, the state's position is that that still isn't appropriate. I mean, the first sentence alone is just not an accurate statement, and I don't think the issue should be presented to the jury that the issue is whether or not they were edited. The issue is whether or not the defendant actually made the recording in the first place. Additionally, we have a potential problem because the audio files, as defense counsel is aware, they were in fact redacted. They removed references to domestic violence incidents between the defendant and Candace Ruiz. So I think that's an inaccurate statement to say, well, if they were edited, then you may consider the fact that they're edited.
I actually was not informed until now that they had been edited to remove references to domestic violence, so that is certainly would be misleading as to the state of the evidence itself, and to do so would then invite the state to explain why they were edited, which would then cause a problem. So I'm not going to give that instruction either. Certainly that's fodder for argument, Mr. Mueller, that you believe that audio files were edited, but the ultimate question to the jury is whether or not there were wire interceptions, unlawful wire interceptions made in the state of Nevada, and if your client is the one that made them. I'm declining to give the instruction, the original proposed instruction and the modified proposed instruction.
And for the record, I object.
Understood, your objection is noted. All right, the next proposed instruction from the defendant is once consent to a phone recording is granted, it may not be revoked after it is completed. I am inclined to give this instruction. I believe that this is appropriate, but I want to hear from the state.
And Your Honor, I'm not certain this is an accurate statement of the law, and I'm not sure it really applies to the evidence in this case. I think there's been some confusion because the evidence that's been presented, we presented the audio files that are the subject of the charges. The YouTube video is only mentioned to provide context and a potential motive for why these files were, why these phone conversations were recorded in the first place. So the YouTube videos are somewhat secondary to the actual offense in this case. So I don't think they don't actually serve as evidence that consent was ever given in this case, and I think it's going to confuse the jury because it's not really relevant.
Mike?
I think where this comes from is Detective Carson was asked by Mr. Mueller about if you revoke consent, is that still a crime? He had said something off the cuff, but I know of no case law. I've done research because I've had 3 cases involving this very charge. I've not seen any case law that stands for the legal analysis of what happens when one revokes their consent. Does that nullify the previously recorded telephone call? Does that nullify anything beyond that consent? And obviously the state of the facts are the audio files are found within Michael McDonald's Google Drive. He obviously pieced those together to make this montage smearing his soon-to-be and then ex-wife. And only in the second version of the YouTube videos there's some advising about being recorded. There's no, in way, shape, or form, implicit consent in this case. At best, there's some kind of passive consent if there was in fact a advisement of being recorded in a phone call proceedings. But there's no explicit consent anywhere.
All right, you're unaware of any case law that states that once consent is granted, it cannot be revoked?
There was a case in, I believe, 2017 or 2018, it was the DITAC case, which is a restatement. It's a civil case that had to do with telemarketing, with a certified question from the U.S. District Court to the Nevada Supreme Court.
Right.
And that analyzed in much older, I think from the late 90s case of a soccer coach making a confession or a recorded phone call while he was on a trip in California, and the admissibility of that statement. So those are all the cases that I know to exist that revolve around this particular statute. Nobody talks about consent and revocation. It's all about jurisdiction.
But the DITAC case, the holding said, we certify the question in the negative, concluding that NRS 200.620 does not apply to recordings of telephone conversations with a person in Nevada without that person's consent when the recordings are made by a party who is located and uses recording equipment outside of Nevada.
Correct, that's the jurisdiction.
But that's jurisdictional as opposed to revoking consent or after the fact, changing their mind on consent. Okay, all right, Mr. Mueller, I hear from you.
Thank you, Your Honor. My colleagues, maybe something's obvious to me that I should spell out. If I state at the beginning of a conversation, hey, I'm gonna record this because I don't trust you, or just like the judge says, we're gonna record this, and then later the conversation turns negative and goes for an hour long, someone takes the conversation and edits out the beginning of the conversation, now I've got an edited tape, I've got an admonishment that's been reduced, and I have an incomplete conversation. Now, I've got the same witness who says that she didn't consent to this, saying, well, when I listened to it, it said, this is call is being recorded. Now, I'm deeply concerned that these recordings have been tampered with with ill motive towards Mr. McDonald. Now, here is, if she says, okay, I don't care, it's called recorded. You can't, then he starts recording it, now she's in here in courtroom saying, I didn't consent. Okay, so once you consent to the recording, you shouldn't hang up, but you can't, revoke the consent once the court recordation is made.
All right, so, first off, for the record, the DITAC case that I quoted from is DITAC Financial LLC versus Buckles, the Supreme Court case from 2017, and the site is 133 Nevada 498, 401 Pacific 3rd, 215. Mr. Mueller, the issue is that there is no evidence that consent was ever made or given in this case. Rather, what we have is testimony that consent was dubbed in. Considering, I'm actually going to reconsider my position. I think that it would be confusing to the jury. Now, Mr. Mueller, again, you're free to argue that there was a recording that apparently said this is a recorded call and that the jury can infer consent, but we have no evidence of that consent was ever given. And if I recall correctly, Ms. Ruiz testified specifically that she did not give consent yesterday during her testimony. All right, so I'm not going to give this instruction, and your objection is noted. Anything else you want to add to the record?
No, Your Honor, there is one instruction in the states that needs to be redacted. The one that says, you are instructed the audio recording of one of the telephone conversation without consent of part or the other is an unlawful interception of wire communication, and it should be comma in the state of Nevada.
Can you give me a page number, please?
No.
No, there's no page number, I'm sorry. I know which one it is, though. It's the one.
Mine is page number.
Oh, did you put it? Oh, okay, it's page 15, I think.
14.
I think it's 16, I'm sorry. Is that what you're talking about? Mr.
Yes.
Mueller? Well, this one addresses Nevada law, so this one says.
There's one right before it that says, 1 second.
Sure.
Okay, it's page 15.
Oh, you want to add under Nevada law
Yes.
at the end there? Any objection, Steve?
That's fine.
Yeah, no objection.
Okay.
So we need the same one.
All right.
It's more of a definition.
So my last, question or issue, if you will, is the verdict form. So we have the 5 counts listed out, but I think that the jury needs to be instructed that they need to find that there were 5 separate recordings in order to find Mr. McDonald guilty of 5 counts of this offense. So I guess I should have got that, and I have a second proposed instruction. And the second proposed instruction should be that the jury, in making their, during deliberations, must determine if there were 5 separate phone calls. Then the verdict form should read, should be a special verdict form. So as proposed, it's fine, but I think we need to add in each part in the affirmative, yes or no. Audio recording 1 was a separate recording from counts 2, 3, 4, and 5, and then go through each count. That way, they're making a determination of 1, it's a separate call, because Mr. Mueller has been arguing in opening statements that it's one continuous call. Because if not, we're going to have an issue with just determining whether or not the jury, A, found there were 5 calls, assuming they find him guilty. If they don't find him guilty, then this issue is resolved. If they do find him guilty, we're going to have a merger issue and a confusion issue as to what the jury decided. Do you understand?
Yes, sir.
Do you have an objection to adding that?
I feel like that would probably be covered just by a jury instruction, like informing them that they need to find that, because I feel like that would cover it, because then if they're finding them guilty, that, and because they're presumed to follow the
So
instructions.
you prefer not to have a special finding form with the checks of yes and no?
I prefer not to add that to the verdict form, but a jury
Okay.
instruction is
All right,
absolutely.
I'll hear from Mr. Mueller.
If I can consider for a moment, Judge?
Sure.
What do you think?
No, we're going to need to, we have audio files that are edited or reformatted, the minimum, have been reformatted. We don't only have in 5 recordings, 1 goodbye, we don't have any hellos. I think we're gonna need to ask for a special finding. We find that these were 5 separate recordings, or we find that these were 1 recording spliced, or multiple splices of 1 original or 2 original recordings.
Well, that does become a little complicated, because the way that I had envisioned this in terms of the verdict form would be count 1, unlawful interception of wire communications. Question 1, we find that this audio recording is separate from recordings 2, 3, 4, and 5, yes or no? Assuming they find yes, then they move on to the deliberation of guilty or not guilty. I don't see how we could do a special finding of, unless we put that first, we find this to be 1 continuous recording. Do you see what I'm saying? That's where things get complicated.
I agree.
The only idea I have is if you potentially add like count 6, which is an optional and comprehensive for a finding of singular call that's still proven.
That was the alternative that I did have in my mind. Do you want that with the special findings, or and then we can instruct them, if you cannot make this determination, then you go to this? If you find
If
a
you
call
believe-
was made,
Yeah, if you believe he's committed the crime, however, you find it's 1 call and not 5 calls, then you find him guilty of 6.
okay.
That might be easier to follow.
Okay.
Obviously, we don't have any information that supports that, but as long as there's agreement of the parties, this is what the defense wants, then it's fine.
Right, it wouldn't really be a count, it would be or, and then just a generic, we find the defendant committed a violation of unlawful interception of wire communications.
Right.
Do you see what I'm saying?
I think we're trying to work this thing through as a chess game. I think we are courting error and a waste and a new trial if we come up with anything other than a verdict that reflects the state's charges. I'm thinking this through. I would like to have some, catch-all verdict, but the reality is we do that, we're not answering the state's charge. As the state's charged by specific theories of liability, they have to make a finding on each one.
All right, so okay, right, I don't think we're inviting arrow in, but I understand your concern. The alternative to that would be, we find it separate. If they find, no, we don't want this to be a separate call, then we instruct them that they have to find the defendant guilty of that, not guilty of that count.
Yes?
Whereas
That
if
would-
they pose, if they could still find the guilty of count 1, then it would be 1 count as opposed to 5.
That would
Why don't I work on that,
Yeah,
and then you guys can take a look at it,
okay.
okay?
For sure.
Email me the verdict forms and when you guys want these, I'll work on the verdict forms. Okay, all right. So, I know, I'll work on the, don't worry about this, I'll work on this. Yeah. If you email me, I'll take a look at it. All right, I'm gonna step back and work on the verdict form and the instruction regarding the determination of 5 calls, and we'll be back.
We will take this case under submission.
That would require proof by very significant evidence.
You both did a good job bringing all this to my attention.
I'm going to make a record about you in a minute. You need to sit down and be quiet.
The court finds in the best interest of the minor child and makes the following findings.
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
Order 9 is back in session.
All right. Back on the record in C-18-333-684-1, State of Nevada versus Michael Lee McDonald. I provided one draft of the updated verdict form, and I understood the state had an objection. Before I learned that the state had an objection, I realized that there was an issue with what I had proposed. So I modified it and created a second one. So take a moment and take a look at that, and we'll talk about why I changed it. Send it to an extra page for no reason, I apologize. All right, and before I finish this, I wanted to ask Mr. Mueller if Mr. McDonald was going to testify.
No, Your Honor, Mr. McDonald has been, I've consulted, and he's been advised of his right to testify, his right to remain silent, his advice of counsel that he's going to follow, that he's going to remain silent. Judge, can I have the answer?
Yes. I'll give you all a chance to take a look at that. If we could put the defendant under oath, please.
Raise your right hand, please. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, nothing but the truth, so help you God.
Okay.
Please state your name for the record.
Michael McDonald.
Good afternoon, Mr. McDonald. Under the Constitution of the United States and the Constitution of the State of Nevada, you cannot be compelled to testify in this case. Do you understand that?
Yes, sir.
You may, at your own request, give up this right and take the witness stand and testify. If you do, you'll be subject to cross-examination by the Deputy District Attorney. And anything you say may be on direct or on cross-examination would be subject to fair comment when the Deputy District Attorney speaks to the jury and his or her final argument. Do you understand that?
Yes, sir.
If you choose not to testify, the court will not permit the Deputy District Attorney from making any comments to the jury because you have not testified. Do you understand that?
Yes, sir.
If you would like not to testify, the court will also instruct the jury, but only if your attorney specifically requests, as follows. The law does not compel a defendant in a criminal case to take a stand and testify, and no presumption may be raised and no inference of any kind will be drawn from the failure of a defendant to testify. Do you have any questions about these rights?
No, Judge.
You're further advised that if you have a felony conviction and it has been received that conviction in less than 10 years, or stated otherwise, that not more than 10 years has elapsed since the date you were convicted or discharged from prison, parole, or probation, whichever is later, and the defense has not sought to exclude that evidence coming before the jury, and you'd like to take the stand and testify, the Deputy District Attorney in the presence of the jury will be permitted to ask you the following questions. 1, have you been convicted of a felony? 2, what was that felony? 3, when did it happen? And that's all the questions they may ask. Do you understand that?
Yes, Judge. I believe I do.
I know you had another case, but I don't believe that judgment of conviction has been entered. Mr. Mueller, is your client a convicted felon as he stands here today?
No, Your Honor, in fact, I'm objecting the motion for a new trial. I hope to have on file by the end of the week.
Understood. All right. And I understand that you want to waive your right to testify. Is that correct?
I believe so, Judge.
Okay. All right. And you were making that decision after consulting with your attorney. Is that correct?
Yes, Judge.
All right. And Mr. Mueller, do you anticipate putting anyone else on the stand?
No, Your Honor.
Thank you. All right, let's go back to, you may be seated. Let's go back to the proposed verdict form. This is what I did, and I certainly welcome comment. I ended up just asking whether or not it's a separate wire communication or not. They could find it to be not a different wire communication, ultimately still find him guilty of the offenses. Then it would be an issue at sentencing, whether there's a merger or some other thing. So that's why I did it this way. I want to let you all know where my head's at, but I certainly welcome argument or suggestions from either side.
And I understand that, Your Honor. We just like a few minutes to just kind of talk to each other.
Yes, and I, of course, would want you all to explain that to the jury
Yes.
as well. And then, I'm sorry, one more question for Mr. Mueller. Do you want the instruction about your defendant's decision not to testify included in the instructions?
Yes, Your Honor.
Did you include it?
I included it.
I did see it, just wanted to make sure. All right.
What do you mean by hold?
And for the record, that instruction will be instruction number 11. And here are instructions for you. Do you mind one for each side? Can you put the jury in a little finishing up here? Thank you.
Your Honor, neither Ms. Mishler or myself have much experience with special verdict. So while we did have some concerns with verdict form version number 1, given that it led to the possible conclusion that if the jury didn't find they were separate wire communications, they could find not guilty on everything.
Correct. That's why I changed it. It didn't really give them the option to find them guilty of one count.
My initial concern with verdict form number 2 is that it was acceptable as long as the defense does not argue the problem with number 1, which is if you don't find that it was a separate phone call, but it is a phone call that was recorded by the defendant, found guilty, not guilty of everything. The only other concern I have, so it's more of an argument, it'd be a misargument of the verdict form, but the second problem, which potentially is there, and again, this comes from lack of experience with special verdicts, is the proposed question A doesn't direct the juror to what to do if it's yes or no to B.
So if you look above count 1, it says you must answer the questions to both subsections A and B.
Okay.
Because I want them to answer both questions. So it shouldn't direct them one way or the other. They need to make a determination. But I understand your concern that this potentially is an issue where if they don't find a wire communication at all, that it's not guilty. I think that's what you're arguing to me.
No, I'm just wondering if appellate-wise, the sort of just too vague at that point. I'm not sure. I mean, if it were not having those languages, it would simply say count 1, unlawful interception of wire communications, guilty of that or not guilty, and then so on and so forth. So I guess this is just as vague as that.
Well, it is just as vague, except for the fact if it's 5 separate counts, I believe you would have the option at sentencing to argue consecutive time.
I understand. So if they checked
That's why the special
yes on
finding would
one
be.
and no on the rest, and then guilty on everything, then you probably only find them guilty and sentence on one, or whatever the case may be.
It does become complicated.
It's, I guess, fine.
The alternative would be that we go back to the original verdict form. You all argue what you want to argue, running the risk that they say yes, and we have no idea if they found it to be one recording or 5 separate recordings.
Yeah, it's fine with the caveat that we wouldn't want the defense to argue, if you don't find it's a separate recording, that it's one recording, then find him not guilty in everything. That's not the spirit here. Certainly, if there's other things.
So that would be an improper argument. The argument would be for the determination as to whether or not a wire communication was made and whether it was intercepted, and if he was the one who did it, right?
Right.
So then the argument from your end was even if you accept that it was one communication, if you find that it was a communication, then you should at least find him guilty of count 1.
Yeah, I don't think we're going to be conceding our arguments where we're saying, oh, it's got to at least be one found guilty on one. We'll be arguing these are 5 separate phone calls, which is what the evidence shows.
I understand. I'm saying that would be to
Yeah.
explain that.
Yeah, we would just probably object if the defense made this argument.
Okay. Do you anticipate making that argument, Mr. Mueller?
They would be essentially conceding guilt on, well, no, they wouldn't be.
I'm not conceding guilt on anything, he's not guilty.
We have a problem with them conceding that it would be one continuous phone call and he's not guilty based upon this verdict.
Sorry, I didn't understand you, Mr. Raman. I know, it becomes a puzzle in your head.
So if they end up conceding that this is in fact a phone call, but it was one phone call chopped into 5 pieces, and under the way this case is charged and the verdict form is read, you have to find him not guilty if you find it is one call. We would object to that. Of everything. Not guilty of everything.
Right, because that's not how it's charged in the information. The information charges on or between a certain date range and there's 5 separate counts.
Right, and there's specificity to what is the content of each call and their separate calls. I don't presume they'll do that, it's just our concern.
All right, Mr. Mueller, anything you would like to add?
No, you're.
All right, in light of that concern, let me just check something real quickly here. Yeah, the letter. Oh, okay, great. Oh, no, the other one. Yeah.
It's smart for them.
Yeah.
We included the instruction I drafted as instruction number 7. Is everyone okay with that placement?
The state is, Your Honor.
All right, Mr.
Okay.
Mueller?
Okay.
Does the state request that we add anything to that instruction that ends with the verdict form?
I'm sorry, could you say that again?
Do you wish to add anything to that instruction to help explain the verdict form?
No.
All right, and Mr. Mueller, you're accepting the instruction 7 as proposed?
Yes, sir.
Okay, all right. All right, so state, do you accept the proposed jury instructions, that I have provided you?
Yes.
And do you accept the amended verdict form?
Yes.
Mr. Mueller, same questions for you. Do you accept the proposed jury instructions?
Yes, Judge, with the reservations of previous expressed on the instructions that you declined to give.
All right, and those objections are noted for the record. And do you also accept the proposed verdict form?
Yes, Judge.
All right. All right, then I think we can go ahead, you can correct Jay. We'll go ahead and bring the jury in.
All rise for the jury.
Thank you very much, everyone. Please be seated. Welcome back. Sorry to keep you all waiting. We were hoping to be done by 2:40, but we had a few more things to finish, and we did, in fact, finish those. So, just to be clear, I can't remember if this was stated on the record, we fully broke for lunch. State, do you rest your case?
The state rests, Your Honor.
All right. Mr. Mueller, do you anticipate calling any witnesses in your case in chief?
This case does not need a defense, Judge. We will not be presenting it.
All right, and therefore are you resting?
We arrest it.
Okay. All right, ladies and gentlemen, so the jury, the defendant has rested, which means we are now ready to roll into jury instructions. My Judicial Executive Assistant, Ms. Beltran, is kind enough to stand up there and display the instructions on the television screen so you can follow along. I'll try not to talk too quickly, but you will have a copy of the instructions back in the jury room with you, so you can take a look at them. You don't just have to read them here and remember all of them, so know that. All right, let's go ahead and get started. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. If in these instructions any rule, direction, idea is repeated or stated in different ways, no emphasis thereon is intended by me, and that may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Amended information is but a formal method of accusing a person of a crime and is not of itself any evidence of guilt. In this case, it is charged in amended information that on or between August 1st of 2016 and November 30th of 2016, the defendant committed the offense of unlawful interception of wire communications, Category D felony, NRS 200.260, 200.690, and OC 50355. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of one or more of the offenses charged. Count 1, unlawful interception of wire communications. Did willfully, unlawfully, and knowingly, okay, you know what, I'm gonna have some water. Hold on, Bob. Start again. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and said Candace McDonald and or Candace Ruiz without her consent, where they discussed daycare costs. Count 2, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed doctors, child protective services, and or allegations of her boyfriend. Count 3, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed her new boyfriend and or dietary needs of the children. Count 4, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed family court proceedings. Count 5, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and Candace McDonald and or Candace Ruiz without her consent, wherein they discuss court issues and or dietary needs of the children. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of this case to determine whether or not the defendant is guilty of one or more of the offenses charged. Each charge and the evidence pertaining to it should be considered separately. The fact that you may find the defendant guilty or not as to one of the offenses charged should not control your verdict as to any other offense charged. To constitute the crime charged, there must exist a union or joint operation of act forbidden by law and the intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove motive on part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. A reasonable doubt is one based in reason. It is not a mere possible doubt, but is such a doubt that would govern or control a person in the more weightier affairs of life. If in the minds of the jurors, after an entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. You are here to determine the guilt or innocence of the defendant from the evidence in the case. You are not called upon to return a verdict of guilt, as to the guilt or innocence of any other person. So, if the evidence in this case convinces you beyond a reasonable doubt of the guilt of a defendant, you should so find, even though you may believe one or more persons are also guilty. The state of Nevada has charged the defendant with 5 counts of unlawful interception of wire communications. In reaching your verdict, you must determine if each audio recording constituted a wire communication, separate and apart from the other audio recordings, and if the defendant is the individual who made them. You are not to speculate what occurred or did not occur during the divorce proceedings that were introduced during the trial, except to consider what, if any, bearing they have on the evidence in this case. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are 2 types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the way to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulates to the existence of a fact, you must accept the stipulation of evidence and regard the fact as proved. You must not speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence and may only be considered as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court, and any evidence ordered stricken or to be disregarded by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his or her testimony which is not proved by other evidence. It is a constitutional right of a defendant in a criminal trial that he may not be compelled to testify. Thus, the decision as to whether he should testify is left with the defendant on the advice of counsel and his attorney. You must not draw any inference of guilt from the fact that he does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. It is unlawful for any person to intercept or attempt to intercept a wire communication. Quote, wire communication, end quote, means the transmission of writings, signs, signals, pictures, and sounds of all kinds by wire, cable, or other similar connection between the points of origin and reception of such transmission, including all facilities and services incidental to such transmission, which facilitates and services include, amongst other things, the receipt, wording, and delivery of communications. Quote, intercept, end quote, is defined as the oral acquisition of contents of any wire, electronic, or oral communication through the use of electronic, mechanical, or other device, or of any sending or receiving equipment. You are instructed that the audio recording of a telephone conversation is an intercept of a wire communication. You are instructed that audio recording one's own telephone conversation without the consent of the other party to the conversation is an unlawful interception of a wire communication under Nevada law. When a person located outside of Nevada uses recording equipment outside of Nevada to record a telephone conversation, the person is not guilty of an unlawful interception of wire communication under Nevada law. Ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using as a defense his ignorance of the law. Thus, when the evidence shows that a person voluntarily did that which the law declares to be a crime, it is no defense that he did not know his act was unlawful, or that he believed it to be lawful. Although you are to consider only evidence in the case in reaching the verdict, you must also bring to consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. In your deliberation, you may not discuss or consider the subject of punishment, as that is a matter which lies solely with the court. Your duty is confined to the determination of guilt or innocence of the defendant. During the course of this trial and your deliberations, you are not to 1. Communicate with anyone in any way regarding this case or its merits, either by phone, text, internet, or other means. 2. Read, watch, or listen to any news or media accounts or commentary about the case. 3. Do any research, such as consulting dictionaries, using the internet, or using reference materials. 4. Make any investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. You may, of course, during deliberations, communicate with other members of the jury while you're in the jury deliberation room and after the case has been submitted to you for deliberation. When you retire to consider your verdict, you must select one of your member to act as a foreperson who will preside over your deliberation and will be your spokesperson here in court. During your deliberation, you will have all the exhibits which were admitted into evidence, these written instructions, and forms of verdict which have been prepared for you for your convenience. Your verdict must be unanimous. As soon as you have agreed upon a verdict, have it signed and dated by your foreperson, and then return with it to this room. If, during your deliberation, you should desire to be further informed on any point of law, or hear again portions of testimony, you must produce your request to writing signed by the foreperson. The officer will then return it to court where the information sought will be given to you in the presence of and after notice to the district attorney and the defendant and his counsel. Playbacks of testimony are time-consuming and are not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so the court reporter can arrange his or her notes. This is her notes. Remember, the court is not at liberty to supplement the evidence. Now you will listen to arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence as you understand it and remember it to be, and by the law given to you in these instructions, with the sole, fixed, and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. Thank you, Ms. Beltran. All right. Steve, when you're ready, I know you have to switch over to the computer.
Yes, thank you. Ladies and gentlemen, the evidence has shown that the defendant, Michael McDonald, recorded 5 phone conversations between himself and his ex-wife in October of 2016. And importantly, he did so without Candace's knowledge or consent. She didn't know these conversations were being recorded, and that's why we're here in court. Now, in every criminal case, the state is required to prove 2 things: that certain crimes were committed, and that the defendant is the person who committed those crimes. In other words, what happened and who did it. And I actually want to address number 2 first, because I can address that fairly quickly. So, who is responsible for the crimes in this case? It's the defendant, Michael McDonald. And this is not what we call an identity case. This isn't some sort of robbery in which someone was wearing a mask and we have to identify them through DNA or fingerprints or something like that. We don't have that here. So how do we know that Michael McDonald is the person who committed this crime? Well, think about it. Who else would have recorded these phone calls? We've had a lot of evidence these phone calls occurred between Candace and the defendant, and they occurred in October of 2016. And you can use your common sense. You have an instruction that tells you can use your common sense when you're deliberating and reaching your verdict in this case. So there were only 2 people in these conversations. Okay, there's no evidence that anyone was interested in tapping anybody's phone here. That would be pure speculation. You have a jury instruction that says you're not allowed to speculate. And when you think about it, is it likely that Candace recorded these phone calls? Not really, not if you use your common sense, okay? Candace, and you get to analyze her credibility yourself, like that's entirely up to you. But if you recall her testimony, I would submit to you she seemed embarrassed just to admit that she was a Hanson fan, let alone publicize things like her daughter's rectal prolapse and other personal things of that nature. And remember, Candace admitted she was using strong language on those phone calls. The sorts of things Candace was saying and how angry she was. Ask yourself, is it likely that she would have been saying these things if she'd known she was being recorded? You also have Mark DeCiro's testimony. And even though there's a slight connection between Candace and Mark, they have one mutual friend, Mark is really more of an independent witness in this case. He's not involved in the divorce. He's interested in the law and what's going on in the case. But he and Candace, their testimony, they corroborate each other. Okay? And you'll have the evidence with you. You'll have all of the exhibits that were admitted. And you'll see the communications between Mark DeCiro and the defendant. You'll see that the defendant just emailed him these links to these Google Drive folders, which is where the recordings were found. Okay. So this is one of your jury instructions about credibility. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. Okay, so this is a case in which it'll be entirely up to you to evaluate the credibility of Candace and Mark DeCiro's testimony, as well as that of Detective Karchner. Okay, that's entirely up to you. And you'll have the recordings of the phone calls to listen to when you go back to your deliberations. Okay, and ask yourself if you found Candace to be credible. And another aspect of credibility is whether there's corroboration. And you'll remember the divorce decree in this case has been admitted as an exhibit, and you'll have that to review. A lot of what Candace was saying about what was going on in October of 2016 and her explanations of what was going on in these conversations is corroborated by what's in that divorce decree. Now, possibly your most important instruction here is your reasonable doubt instruction. Okay? A reasonable doubt is one based on reason. And the most important part here, doubt to be reasonable must be actual, not mere possibility or speculation. So what does that mean? When you're deliberating, okay, any doubt would have to be reasonable, and it can't be based on speculation. So any sort of speculation that someone tapped a phone, that someone not even related to this case tapped a phone or anything like that, that's pure speculation. Your deliberations have to involve the actual evidence, the comparison and consideration of all of the evidence that's been introduced in court, which includes the testimony that you heard on the stand, as well as all of the documents and the audio recordings that were admitted as exhibits that you'll have to review during your deliberations. That also means there's no, if you did hear some questions from defense counsel regarding whether or not the defendant went to California. You have another instruction that tells you that the questions asked by attorneys are not evidence. Okay? The answers to them are evidence, but not the questions. So any consideration along those lines would be pure speculation. Okay. Now, the crime that was committed in this case, one crime committed 5 times. It's called unlawful interception of wire communications, often commonly referred to as wiretapping, but this is the full title in Nevada. So there are 5 counts charged, 1 for each reported phone call, because the evidence has shown we have 5 separate phone calls here. So your first instruction regarding this charge, it is unlawful for any person to intercept or attempt to intercept any wire communication. Now, next you have a couple of technical definitions. So what is an intercept? The oral acquisition of the contents of any wire, electronic, or oral communication through the use of any electronic, mechanical, or other device, or of any sending or receiving equipment. So this is very broad. It doesn't require particular types of equipment being used to intercept that wire communication. Any sort of interception qualifies. And wire communication, I'm not even going to read this out to you. This is a very technical definition, because the next jury instruction clarifies it. The tape recording of a telephone conversation is an intercept of a wire communication. Okay? So if you believe that the defendant tape recorded these telephone conversations that you heard, and that he did so without consent or permission, then you can find the defendant guilty. And just to be clear, recording one's own telephone conversation is not legal in Nevada unless you have the consent of the other party to the conversation. And the defendant did not inform Candace that the conversations were being recorded. Now, there were some questions about the location, because in order to be guilty of this crime, the person who is conducting the interception, who is intercepting the telephone call, needs to be located inside of Nevada. Okay? And again, you can use your common sense when you evaluate the evidence in this case, because all the evidence points to the defendant would have been in the state of Nevada. He lives in Nevada. He lived in Nevada at the time, and Candace stated she'd never known him to live anywhere else. He worked in Nevada. He worked at a company called Geotabs. He had shared custody of his children at the time, and he couldn't have just taken them out of state without informing Candace of what he was doing, and that's there in the divorce decree. And it states that right here. He would have to provide a travel itinerary indicating that he was taking the children out of the state. And we heard Malia's voice on some of the phone calls. That's why Candace says, "Hi, baby," on one of the phone calls, because Malia is with Michael, and she's doing baby babble in the background. And Candace was well aware of where he was residing at the time, and he would have been required to notify her had he relocated. And we also know that he took Malia to the doctor here in Clark County, Nevada. Clearly, there's no indication, no reasonable basis for believing that the defendant was outside the state of Nevada when he recorded these phone calls. And Candace testified that she was here in Clark County, Nevada for all of these phone calls. So this was a crime that occurred entirely inside of Nevada. Okay, so jurisdiction here has been established. Now, I want to go over some things because hopefully we didn't distract you by reviewing some of the things that happened with the divorce in this case. And the only reason that the divorce decree and other things related to the child custody arrangement between Candace and the defendant was even relevant here is because that was what was discussed on these phone calls. Okay, and had the conversations been something far more mundane and less contentious, even if they'd just been discussing movies or something completely calmly, then this would have been a very different case. And it still would have been a crime, just possibly not as emotionally charged. But that's the only reason we discussed their divorce at all and introduced the divorce decree. It's only relevant because I wanted you to understand the context of these conversations, so you knew what Candace was talking about, and so you would see how she could tell when these conversations occurred, and then we could determine whether or not the defendant was here in Nevada at the time. So I hope you didn't find that as a distraction, because you're not here to determine like if one party was wronged in the divorce or anything like that, or if you agree with the child custody arrangement. Okay, it's understandable to be curious about certain things and try to work out the timeline, but all you have to consider here is whether the defendant is the person who recorded those phone calls, and whether they were recorded without consent, and whether the defendant was here in Clark County, Nevada when he did so. Okay. And I want to make sure we're somewhat clear on the timeline, because the order of events is important here, and I don't want you to get distracted about the YouTube video that was talked about. The order of events here is really pretty simple. Candace filed for divorce in 2015, and that divorce was finalized in October of 2016. The divorce decree was written and submitted to the court October 21st of 2016. You'll see that on the first page of that divorce decree. And eventually it was actually signed by the judge October 27th of 2016. And that's when it went into effect. And it describes the custody arrangement that they had, which allowed Michael the defendant, to see his children 2 weekends a month. Now, then in March of 2018, quite some time after these phone calls have occurred, that's when Candace is notified by Mark that these phone calls are found in the defendant's Google Drive. And around the same time, she also goes on YouTube and realizes that Michael has posted these same audio files with accompanying pictures. Nevada court watchers, people on Nevada court watchers see this. They start commenting on it and start pointing out that it's illegal to record phone calls without a person's consent. And then what happens? Well, on Michael McDonald's YouTube channel, he posts the same video just with additional audio saying, Candace, you're being recorded, which both Candace and Mark said did not sound like it was actually part of the original conversation for a number of reasons, because the voice was in a weird monotone, it didn't match the rest of the conversation. Okay. And then Candace reports this to the police. Okay, so that's the timeline that we have in this case. And I just want you to understand that because it gives you the background for understanding the charges in this case. And eventually, those videos are removed from YouTube. Okay, that's not under our control. As the witnesses testified, it was the defendant's YouTube channel. So I submit to you that we have proven beyond a reasonable doubt that the defendant committed 5 counts of unlawful interception of wire communications.
I ask that you find him guilty of all 5 counts. Thank you.
Thank you, Ms. Mishler. Mr. Mueller, when you're ready.
Ladies and gentlemen of the jury, not guilty on all 5 counts. There are so many things wrong with this case that it's going to take a few minutes just to make a laundry list of them. But before we get to that, I want to take a few moments and talk. I want to thank you for your jury service. It's inconvenient, it's time consuming, it's time out of your days, and unfortunately, money occasionally out of your pocketbook. Thank you for being here. I want to talk a little bit about jury service. I started off as a very hard-bitten, cynical young man, and what I've learned from these experiences of standing in front of juries is they work very well. And the reason we have juries is because each of you on this planet have 10, 15, 20, 30, maybe more years of adult life experience. You know how people behave. You've dealt with people every single day of your life. You know what is credible and you know what is not credible. And collectively, the wisdom of you together produces a much better verdict than any one person does. So, thank you for your service. And when you come and go back, deliberate, please take your time and do a thorough job. Now, the case at hand. When you go back, I don't normally like to go, I don't want to sit here and spend a lot of time, but there is one jury instruction that I would like you to pay very close attention to, number 19 in this particular package. It says that you are to use your everyday common sense and experience. We have machine fitters, we have veterans, we have businessmen, we have massage therapists. We have a very wide variety of people from a number of different backgrounds, okay? Now, when you get back there, you don't need to check into legal land. You need to use your common sense and experience and look at the evidence. Now, my colleague stood up here, and I'm going to get down to brass tacks here, and we're going to start analyzing this particular case. My colleague sat here and mumbled past the evidence. The evidence, not the feelings, not the hurt feelings, not the emotion. The evidence in this case was, just like I told you in opening statements, a busybody who had no business gets involved in somebody else's divorce case. He takes, and my colleague stood up here and she said this case is about privacy. Remember that? Privacy was a word she used. I wrote it down. Privacy. The very first witness they put on the stand, Mr. Mark DeCiro, violates the consent to look at the Google Drive. He says, I want you to look at the YouTube videos. Maybe give me a help. He violates Mr. McDonald's privacy. He gets up here, and Mr. DeCiro didn't want to be here. You could tell by his demeanor on the witness stand, he was uncomfortable. We asked him a lot of questions and got a little heated, but that's how the truth comes out sometimes. You put people under emotion, you put them under a little stress, and they say things. Now, here's what he said. When was the recording made? I don't know. Who made the recording? I don't know. How was the recording made? I don't know. Was the recording made in the state? I don't know. That's evidence. He's the 18-year professional radio guy with expertise in editing, reformatting, and audio files. And that's what he told you. I don't know when, I don't know where, I don't know how, I don't know who. Those were his testimonies. Now, let's talk a little bit about something that was very disconcerting. There's 2 versions. They gave you one version, but he said there's another version that says this phone call is being recorded. Where's that version? Why isn't it here? What does your everyday common sense and experience tell you if there's evidence that the state's witness tells you exists that would exculpate Mr. McDonald, but it's not here? What does that say to you? Like, says like maybe somebody doesn't want the truth to come out. So, that's what he said. There's another version of this. It was his opinion that it was dubbed in. So where is it? Why aren't we going to hear it? Because you're not going to get a chance to hear it. Well, all right. Let's talk about the detective. The detective gets up here, and he violates, and he admits he violates. I don't know if you saw his chagrin when I kind of asked. I said, well, detective, isn't that the golden rule of a detective? You don't assume anything? Isn't a good detective got a little placard on your front seat of your dashboard of your car? Assume nothing? Yeah, you're right, Mr. Mueller, it is.
Well, I assumed it was in Las Vegas. That's what he said. I assumed. Well, detective, who made the recordings? I don't know. How were they made? I don't know. When were they made? I don't know. That's what the detective says. That's the evidence of the case. This isn't the feelings, this isn't the passion, this is the evidence of the case. I don't know any of this. What? So I asked a very simple, straightforward question. Why don't you go talk to anybody? Well, we're afraid to go talk to people for fear that it's going to escalate things. For fear it's going to escalate things. That's why you're sitting here. Because the detective was afraid if he went and asked any questions, it was going to escalate things. Now, we're 2 witnesses into the case, and we have literally no evidence who made the recordings, when they were made, how they were made, or that Mr. McDonald made. No evidence. So the state is now 0 for 2. Then we come in, and God bless it was a long afternoon yesterday. Here's the quote. Pay me, Michael, I'll come after you. I'll call the district attorney's office. That's in there. I'm not making this up. That's the exact word she wrote. And here we stand. And there's the district attorney's office, and there's Mr. McDonald. Her anger and her bile could not be more palpable. You heard that audio tape. It was humiliating. It was embarrassing. It was heart-wrenching. You do what I want, or I'm going to wreak retribution. You're not going to see your kids. You're going to go to jail. You're going to be in trouble. Do what I'm telling you to do. Now, in your everyday common sense and experience, what kind of person is that? Is that a good person? Is that a person above manipulating things to their own advice? No, it's exactly the kind of person it was. So let's talk about coincidences. When you get to a certain age in life, you stop believing in coincidences. Things don't just happen accidentally. Things kind of fall together. Now, well, yeah, I know Mr. DeCiro, and yeah, my friend works with him, and well, yeah, I guess he just kind of happened to get involved in my divorce case, and well, yeah, it was just coincidence, and yeah, it was him who got the audio tapes, yeah, just coincidence. Bull. No such thing as coincidences, and we all know that. All right, nonsense. Now, let's go through and let's see what she said that was credible. Let's see what she said that wasn't credible. We know she's animated by bile. You can hear it. You heard it in her voice. You heard it yesterday. You heard it today. Okay? Do what I want, Michael, or I'll call the district attorney's office. So here we stand. Well, let's go through a few things. 2 years later. 2 years later. If I reach out right now and punch somebody in the nose and then make a phone call and complain about it in the year 2022, am I really upset about that? No, I'm not. Why would I call someone 2 years later? To manipulate things to my advantage. You heard it? Mr. McDonald hasn't seen his kids. She made sure she said that. Now, 2 years later, a complaint goes out about a phone call. Now, let's look at the facts and circumstances. We know she's angry, but she said something else that was actually fascinating. Oh yeah, Ciro's right. There are actually 2 versions. And even though one of the versions said, this call is being recorded, I too didn't find it credible because it doesn't serve my interests. 2 versions. Don't you think you should have been at least allowed to hear both? Now, ladies and gentlemen of the jury, this case has many flaws. So let's use, and I'm going to calm down for a moment and get a sip of water, and let's talk about some common sense. Thanks, Mike. Don't spill, please. Thank you. Now, sometime tonight, when you get done or you take a break in deliberations, every one of you is going to call a friend or a loved one or maybe an Uber to get a ride. And the first thing you're going to say is, hello, how are you? Hey, baby, what's up? Hey, I'm on my way.
Objection, golden rule.
The answer is we all use phones.
Objection.
It's not the golden rule, Judge.
It's a very simple vignette to tell people how they use phone calls to underscore the fact that 5 of the conversations don't have hellos.
It's overall at this time.
Now, that's your everyday common sense and experience. That's how we all communicate, every one of us. Pick up the phone, you say hello. I got 5 recordings, not 1, not 2, not 3, not 4, but 5 recordings where nobody says hello. All at about the same time, all about the same subject. What does that tell you in your everyday common sense and experience? The audio tape either didn't begin at the beginning, or the word hello was removed. Or maybe all 5 of these recordings are in fact the same conversation, because one of them does in fact have goodbye. I go, it's the old Beatles songs, I say hello, you say goodbye. We got 5 hellos, we got no hellos, I got 1 goodbye. And then I've got a redacted or a reformatted audio tape that both witnesses says contains the words, this phone call is being recorded. But at the beginning, we have no hello. Very common sense way of exploring this evidence is it was there, it was removed, the conversation chopped up into bits, and her exact words were, you pay me, Michael, or I'll come after you. That's what she said. And you'll have the audio tape back if you listen to it. Now, the other practical problem the state's case has is they got to prove it's in Nevada. We mentioned this earlier. 50 different states, all of them have different wiretap statutes. Two-party consent, as Mr. DeCiro correctly pointed out, was a relatively recent law. The detective said these records were so old that they couldn't get verifications. I want you to understand that. They waited so long to report this that he couldn't get the mobile verifications for the phone calls.
Objection misstates the testimony.
More respectfully, it doesn't.
The jury is going to rely on their own memory as to what the testimony was. The objection is overruled this time.
Congratulations, you threw me off my thought. Give me a second. Good job, Counsel. I don't want to talk this to death, folks. This is common sense. We have some very educated, very accomplished people on this jury. We have people who know how to think. We know people who've been around for a while. And you got people how to sort things out. All right? Do you believe that Ms. Ruiz is a disinterested, dispassionate conveyor of truth and recollection, or a self-interested person? Evidence clear. Listen to that audio tape again. There'll be no doubt. She's self-interested. Even if she doesn't intend to lie, she's very clearly coloring the facts. And even she says that, yeah, there was another version that says, you're being recorded. She can't remember Mike going to California, but that's that. DeCiro says, yeah, there was another version that says this conversation is being recorded. But I want you to understand, when you go back there, and this is very important, there's not a scintilla of evidence, not one, about who made the conversation, recorded the conversation. Now that is what you're here to determine, not evidence. And though it is hard, because you guys heard all the emotion yesterday, this is not a divorce case. It's not a divorce case. This is a criminal case. The state must prove that Mr. McDonald made recordings in the state of Nevada beyond a reasonable doubt. That is a doubt that controls the weighty affairs of life. If you can't reach that, just like we said on Monday, then the presumption of innocence favors Mr. McDonald, and he's entitled to a finding of not guilty. Now, one other issue is going to come back. One other issue is going to come up in the jury room deliberation room. Special verdict form. You're going to have to determine if this was even one recording or 5 recordings. So listen to it. Listen to it in total. What's just jarring about this audio recordings is only one of them ends in the word goodbye. None of them end. None of them begin. That says something. Was it one recording? If it was one recording, then you can't convict them of 4. You can't convict them of 5. And then, once again, even if you find this one recording, you gotta find that Mr. McDonald did it beyond a reasonable doubt. Now, please take your time, look at the jury instructions. My suggestion is read them in detail, go to number 19, the everyday common sense, and come back and get a copy of the special verdict form. Now, was number 1 and number 2, is that a separate?
Objection, I don't think it's intentional, but that's the wrong.
Grab the one.
Thank you. Okay, thank you. Go back here. First recording of separate wire communication, the answer is no. Did they prove that the case was wire intercepted, that Mr. McDonald did it beyond a reasonable doubt? The answer is no, not guilty. Was audio clip number 2, was that separate recordation from the other ones? The answer is no. It doesn't begin with hello, it's pretty much a continuation of the same discussion. And has the charge been proven beyond a reasonable doubt? The answer is no, not guilty. Number 3, once again, we don't have the word hello beginning anywhere. Any indication that this was a separate time or a separate place? Is this the same wire communications? The answer is no, and therefore he's entitled, and we have not proved it beyond a reasonable doubt. He's entitled to the finding of not guilty. Number 4, unlawful wire communications. The 4th audio recording is a separate wire communication. No, this is the one that actually does end in goodbye, but it doesn't begin with a hello once again. Guilty of interception, the answer is no. Absolutely no evidence as to who actually made the recording. And number 5, unlawful intercepted wire communication. Once again, this is not a separate communications, and once again, the state has not proved the charge beyond a reasonable doubt, not guilty. Now, the state has, strictly speaking, done something that is strictly impermissible. They are asking you to look past the evidence and conclude who else would have made it. That's not what criminal law is about. Criminal law is about beyond a reasonable doubt, and that the state has to have some proof at all. We have no convictions, we have no confessions, we have no admissions, we have no anything, literally. They just assumed it had to be him, and that's actually exactly what the detective said. I assumed. So ladies and gentlemen of the jury, please, when you go back there, take your time, go through it. It's a very important decision, but it is also a very easy decision. Not guilty across the board is a proper outcome, and on behalf of Mr. McDonald, thank you, appreciate your time.
Mr. Mueller. State. Rebuttal.